pause the recording.
So let me just go through what our subject is going to be today. We'll go right about an hour and we want to leave some time for Q&A. So we just went through the introduction. We'll talk a little bit about renewable energy growth in general. We'll discuss interconnection queues and some of the challenges that have come because of interconnection queues and logjams. Then we'll talk about some of the regulatory reforms in the state and federal level. Very general, there are just too many efforts in all 50 states, provinces, and the federal level to discuss them all. We're just going to hit on some highlights. Also, we'll discuss, and I think probably this is what many people are most interested in, is how some developers have acted to move their projects out of that regulatory queue, out of that logjam. And then we'll conclude with some pointers and information for you, and finally some time for a Q&A. Just as a reminder, if we don't get to your question, please put it in the chat later on, and we'll do our best afterward to address that. So as many of you know, renewables have become increasingly cost competitive. Wind and solar energy costs have fallen to 70 and 89% of what they were 10 years ago. So in a period of 10 years, and as you can see, costs are even dropping even further. They've become very cost competitive. And overall, it's probably the #1 area where electrical energy is being produced from, renewable energy sources. There have been some supply chain issues in the past year, especially in the United States with some tariffs. Costs have increased, and so there may be some slowdown, but generally speaking, it's expected that renewables are going to probably dominate the source of most electrical energy in the United States. The two primary sources of renewable are solar and wind. There's renewables, hybrids. Obviously, battery storage is making a big dent and making those more available to people within the United States and across the world, really. But those are the two biggest sources of renewable energy, with solar being the leader. For example, I'll just give you some stats for solar. In Q3 of 2021, the solar market installed 5.4 gigawatts of capacity. Utility scale solar was at an all-time high, with 50% of all new generation capacity being solar. It set a record for installations in Q3, and a total of 6.1 gigawatts of new utility scale solar PPAs were signed just in Q3 of 2021. When we're talking about interconnection here, essentially it's the process by which a project will pump its electrical into the grid. And typically that involves a few steps. If you've been involved in interconnection, you'll understand that this process is highly complicated, but I've broken it down into 7 general steps. So one is obviously the interconnection request, then come the studies or usually studies. Then you sign an interconnection agreement with the end user. There's some interconnection agreements with the utility or cooperative through which your electricity will pass. Then we have new resource implementation. So within a grid, or you will have multiple generators, and that just involves putting your resource into the mix so that for planning and reliability purposes, the ISO, RTO, or utility can know what's coming into its system. Then there's everything involved in getting a sync date, for example, permitting, engineering, procurement, and then obviously construction of your plant. Then you'll have your trial operations to make sure all safety and reliability concerns are resolved. And finally, your commercial operations date. And after that, obviously, you have another 20, 30, 40 years of maintenance, which involves a whole nother set of regulation at the state and federal level through NERC, FERC, and also state laws, but we're not going to be discussing those today. And so what's the problem? What's the issue with queues and logjams? Well, essentially, as you know, energy is produced away from the homes. For example, you may have a solar panel farm a few miles or 100 miles away to where the energy is. And the queue essentially has to do with getting the electricity from where it's made to where it's going to be used. And that's not as simple as just trucking it out there, obviously. We have to have the wires to take that energy. And one thing you have noticed in the past year, I do a lot with transmission. Transmission is one of the things that interests me. We've all seen probably articles and news stories in our specialized media about the looming challenges with regards to transmission. But one thing I've noticed is that popular media is really seeing the challenges coming on because of the increasing renewable energy mix. You'll see that, example, Wired, this is a pretty simple magazine, is talking about the renewable energy slowdown or possible inevitable slowdown because of lack of transmission. The New York Times, the Atlantic, and it's becoming an increasing challenge for renewable energy providers to get their energy to where it needs to go. Excuse me. So there's essentially 3 points that we've seen, that I've seen, have really constrained the ability of generators or developers to get their energy. One is frankly an inadequate process for interconnection. As many of you know, there's long interconnection queues. The system impact studies are generally very unpredictable. They can go on for a long time, especially as new generators or proposed generators come online. Studies have to be reevaluated. There's sometimes poor coordination between the transmission provider and affected system. An affected system in the United States could be, for example, an RTO or ISO region. And frankly, excessive costs for upgrades. I don't think I have to tell any of you that are involved in this that those costs can either make or break your project. The second part is essentially a system that's old. It really wasn't made to take on the type of renewable energy that we're seeing coming online. There are, in many instances, wires and transmission lines that are decades, if not 100 years old. In my line of practice, I have seen operation agreements that were from the early 1900s, especially in the Pacific Northwest of the United States. And they never, I think, anticipated the type of new energy mix that's coming on. Inadequate points of interconnection, transmission, just essentially what I call structural challenges to putting that energy on. Excuse me. And then most recently, obviously, supply chain issues. For example, months of disrupted shipments due to the AD/CVD petition. And that is essentially expected to lower building out by 25% in 2022. Today, we're just going to focus mostly on number one, in other words, the process for interconnection. But again, if you have questions, feel free to send those to me. So what are the consequences? These are some of the consequences. As of 2021, there were 755 gigawatts in queue nationally. That's a large amount. That's a huge amount. Soft costs are essentially those costs related to developing your project that aren't related to the physical project, the physical machine that produces the electrons. And those soft costs have gone up 50 to 100%, which is a significant amount, obviously. There's been a 100% increase in the past 3 years in upgrade costs for wind and solar projects. So for example, when a project wants to come online, the portion that's allocated to them from either an incumbent utility or another affected region for those costs have increased, and in some cases made projects drop out of the queue completely. For the two biggest ones, this has led to pretty abysmal rates of approval. For wind, it's about a 19% completion rate as of 2021, and for solar, about 16%. So if you average those, it's about 17.5%. And this has led to some real world impacts. For example, in Hawaii, it's well known that AES's coal plant that produces, has a nameplate capacity rating of 203 megawatts is going to be shuttered in September of 2022. It provides about 10% of Oahu's firm electrical supply. There is not enough renewable energy coming online to replace those 203 megawatts. In fact, recently, Engie North America scrapped a 60 megawatt solar plus 240 megawatt battery storage facility, which I think was a surprise for many people, leaving hopefully other projects to get online. But now I think there's whisperings that perhaps other projects may not proceed, leaving a pretty big worry for legislators and stakeholders here in the region. And obviously for ratepayers, that is going to lead to rolling brownouts and blackouts if that energy isn't provided, isn't made up. I'll give you another example. In 2019, in one MISO study group, So MISO is Midwest United States. 3.5 of the 5 gigawatts that were in queue dropped out of the process, dropped out completely. Some of these projects already had PPAs in place, and they dropped out due to very expensive interconnection costs. So you can imagine the cost of having spent millions of dollars only to have a project drop out. And the result is only 250 megawatts of the 5,000 megawatts in queue withdrew. And of those 250, there were only 2 projects. So think of that number, 2 projects left to make up 250 megawatts of that energy. These are the real impacts of having these interconnection challenges. There has been some state reform. Again, there's too many reforms in place to list here, and I'm just going to list a couple. There have been study reforms. Some states have gotten on board, led by the PUC and the industry, working together with some of the incumbent utilities. And they have led to some reforms. For example, one very common one is allowing cluster studies versus a serial study. A serial study is essentially where you do one study after another. You have a generator asking for interconnection, you do a study. You have another one, you do a study. Well, those can be obviously very time consuming. They don't allow for consistencies or coordination of different projects. And so public utilities commissions and other incumbent utilities are allowing cluster studies. That's just one. There have been movements as well at different state utility commissions to increase transparency for the studies involved, for methodologies, base cases. There has even been some movements in some states to allow multi-stakeholder responsibility for the maintenance of certain base cases. In some areas, like for example, in the Western Interconnection in Western North America, there are regions, for example, the Electric Reliability Administrator, their WEC, has responsibility for base cases, and those are often provided to anyone that is willing to sign protections on that sharing of information. But that really varies from state to state or region to region. On the federal level as well, some very key important initiatives. You may have already attended one of the public docket hearings that they've had. I did. It was very interesting. The first one is an ad noper. Essentially, they telegraphed to us, to the public, that they will be instituting new rules, and the title of that docket is listed in the first one, Building for the Future Through Electrical Regional Transmission Planning and Cost Allocation and Generator Interconnection. For those of you familiar with FERC Order 1000, it was passed essentially with the hope that it would build or spur the building of transmission lines in the United States. I think it's safe to say it didn't really have that impact. It didn't have the impact of building the long lines, miles or hundreds of mile long transmission lines that we had hoped. And I think some FERC commissioners have expressed concern and essentially admitted that that really didn't have the impact that it was supposed to have. So I think with this docket, the federal government is going to be looking at FERC Order 1000, looking at the current resource mix, especially with eyes to renewable energy, and seeing how FERC Order 1000 can be improved. Number two is actually was pretty exciting for me, and I think a lot of you as well. There has been a lack of cooperation between the states and the federal government, especially between what we call the seams. So if you understand our legal structure, you understand that FERC essentially oversees all the electrical crossing borders, state to state. And then the state controls everything within the state. At the seams, in other words, where those areas and regions meet, there has been really a lack of leadership or coordination, I guess you could call it maybe instead of lack of leadership, a lack of coordination. So to see this docket and where FERC went out and actually recognized that this problem wasn't going to be solved without state involvement was a really good thing. You can look at these two dockets. You can go to the FERC website and sign up, and you can get notices of when the hearings are. I think the last one was in November, and I think the next one is coming up in April on the first one. But you're also free to make comments on those. There are some other federal dockets that have brought good news to generators, but I'm not going to discuss them here, and I may mention them later. So what does this mean though for you? Let me point out this situation. You may be a developer who says, look, I've been in the queue for a year, 2 years. We spent millions of dollars. We're still waiting for studies. We don't know how these studies are going to come out. We don't know how the interconnection costs are going to come out, and ultimately whether this project is going to go forward. And the state reforms, federal reforms are all well and good, but ultimately it probably won't, these reforms won't be done in enough time for me to either benefit my project or in some cases maybe even save my project. And some developers have recognized that and taken matters into their own hands at state PUCs. And that's one of the things I'm going to focus on today. So what are some of the triggers? Why have developers sought relief at either FERC or a state PUC? Well, these are some of the things you may see that some of these reasons are familiar to you. There's severe delays in system studies processing. We're talking, I think the last time I looked at a report, it said that most studies have gone from 3 to 5 years, some wait times, and some studies in some areas are even longer. So if you think about waiting for studies in queue to be done and waiting 3 to 5 years before knowing whether your project will ultimately be viable, that's a pretty big risk. Studies fail to adequately allocate upgrades by project or utility. There's discrepancies or wrong information in the system modeling methodologies, study models, base cases, etc. There's overcharges on interconnection cost, a lack of transparency on upgrade costs. For example, identifying what's really a reliability or safety upgrade versus gold plating that is not required. There's a failure to provide accurate information for points of interconnection or just lack of information on which point of interconnection is the best. Failure to comply with interconnection procedures as to a particular developer or inconsistent approaches as to certain developers. Or for example, utilities using different studies for similarly situated developers. For example, using different year studies for essentially the same thing to do the same project. And these are things that have caused developers to find that going to a state PUC is going to be beneficial for them. What's some of the relief requested? Take a look at some of this relief and see if you could use some of this. There's an order from one commission for the revision of the tariff related to interconnection processes across the system. So essentially the reformation of the pro forma PPA or IA. There's been a request for reimbursement of interconnection costs, study related relief, for example, more transparency in the studies, base cases, the sharing of conclusions or processes within the study, an overhaul of interconnection processes in general. They've requested fast track processing for projects that need to get to COD quicker in order to meet with contractual or financing obligations. There's been a request to cap cost to allocations. There's also been financial penalties that are requested against incumbent utilities for their delay in their interconnection processes. And in some states, as we'll discuss, those have actually been granted, in particular one that was assessed a $1 million penalty for a faulty, what the commission found was a faulty interconnection process. There's been requests for investigations or audits of interconnection processes, demands for requiring a time frame for studies, the allowance of cluster studies over serial studies, and many others. These are just a few that I think many of you developers could use perhaps in some of your projects in your particular region or state. And when I talk about that, I mean in every single state in the union, from Hawaii all the way to New York. So what's the grounds for relief? These are some of the grounds for relief. If you've done work at a PUC or an administrative agency, you'll recognize these terms of art. And so these stem from state PUC rules, previous PUC orders, FERC rules, and laws. So I'm going to let you read while I explain something. One of the benefits I think that developers have found is that in contrast to perhaps seeking relief at a state court or a federal district court, is the process is typically faster. So that's why you'll see these grounds for relief are not contractually based. They're not business torts. They're based on the relief that can be granted usually only at a PUC. So that's why they have gone to the PUC for relief. Again, why have they gone to the PUC or why have they gone to FERC? And I'll read some of the reasons here. First of all, like I mentioned, there's broader grounds for relief. And typically that relief sought can be faster than going to the state or federal district court. And this is important for this simple reason. You as a developer might say, look, I'm already online to get my project interconnected in 8 years. The last thing I need is to go sue and be involved in a lawsuit for 3 or 4 years. But what I'll point out to you later is that that typically is not the case. And in the cases, the dockets that we found across the nation, it actually is much quicker going to the state PUC than a state or federal district court. Second of all, state PUCs can consider public interest. They're an animal of the legislature, and so therefore they're tasked with implementing legislative policy from the executive branch or the legislative branch. And in the opposite to what a state court, for example, they probably couldn't really look at public interest and public wherefore. That's one of the main reasons why a state PUC exists. And you will find another reason why is, I'm going to jump down to the last one, you'll find a receptive PUC in many cases, in many areas, that knows they have goals for renewable energy development. They know there's bottlenecks in the process and their system, and that unfortunately sometimes they need to spur the incumbent utility on to make those changes. One other reason is that developers are going to state PUCs or FERC. You have a specialized quasi-judicial body ready to deal with these highly technical subject matter. Engineering, economics, interconnection processes, they're all very complicated. They take multiple technical experts to explain, and these bodies are usually well-versed in the type of law and the type of methodologies used to reach different conclusions in different areas of the law. Again, let me reiterate this. I think generally within the states, we're finding more receptive public utility commissions. I'm going to quote here a portion of an order that the Hawaii PUC mentioned when they were launched an investigation into some of the interconnection processes of the local incumbent utility. And this is what they said. This lack of transparency in the interconnection process, in the company's conduct surrounding the interconnection process, has resulted in the potential for significant setback to renewable energy that could seriously jeopardize cost-effective retirement of the AES plant and impact reliability of the Oahu grid. So here you have a PUC very vocally, very blatantly, essentially saying we have some challenges and we are going to hold your feet to the fire in a way, incumbent utility, to make sure that these goals are met. You can see that state utilities are looking at public goals, the public welfare, and I think you'll find in a way a receptive PUC. The example I had mentioned before, it was an example in Minnesota. This was in the news, it's public information. Again, this actually was with rooftop solar, but it's really incredible in the fact that the PUC specifically said and affirmed the right of consumers to reasonable customer service in the interconnection process, including as to the time for interconnection. And because of the number of complaints, I believe the number of complaints was over 100, they essentially fined the utility there $1 million and held an investigation until the interconnection process was sped up and improved, increased transparency. And I think as you go through different state utility commissions, you'll find many states are very willing to provide the relief that many developers need. One note, developers might be worried about, well, I don't know that the best thing if I go and sue or file a complaint against a utility in a state commission, and that may be true. In some cases that we've found, some developers have, for various reasons, individually or maybe with a partner, a joint venture partner, go and file these complaints at utility commission. In some cases, however, they have joined with industry members, maybe a state or regional group of renewable energy industry members, to file either complaints or motions or take other action at the utility commission. One thing we found as we've scoured these dockets is that from the time of the filing of the complaint to the time where there's a settlement submitted requesting or essentially dismissing the case because settlement talks have proceeded to a level that a developer was comfortable with dismissing the complaint, they typically see anywhere from 6 to 9 months. In some cases I've seen within a period of 3 months, and that's the filing of the complaint, an answer and a reply. And sometimes in some cases you'll find a serve reply or serve rebuttal. but it's typically the pleadings that come up. And I think for whatever reasons, the filing of those complaints will spur the incumbent utility or cooperative in that area towards settlement that they previously weren't willing to engage in. So consider that fact. If you're 4 or 5 years away from interconnection or from your COD, you may want to see what type of action you can take at the PUC. In one state, for example, there were significant gains. If you see here, you'll see a drop of 15 million. There was a group of developers that cooperatively, together were assessed an amount of $15 million in interconnection cost. And after filing complaint and getting the utility to go to the table, the negotiation table, it dropped to $375,000. And the utility agreed to a complete overhaul of the interconnection process, including developing an electronic system for processing those applications. In another state, it led to an audit investigation of the interconnection process, which was pending while the settlements were negotiating. So this really doesn't stop the interconnection process. It spurred it on with the oversight, of the state PUC. And in fact, the state PUC in this case held in abeyance penalties, but said that pending negotiations and the settlement, they would consider penalties to the incumbent utility. In another state in the East Coast, there was a complete overhaul of interconnection procedures and timelines, leading to several hundred megawatts being moved up in queue for completion in 2021 and 2022. And in fact, that state and that region has actually become one of the leaders in renewable energy growth, really surprising a lot of people. And their interconnection process isn't perfect, but it has become a leader for many other states and regions. You'll see some other changes here. You will see that those changes that developers request are either done at the state PUC level within a state or within an RTO or ISO region. One thing before we move on is here at the bottom, I want to mention too that as developers, as you think about what your strategy should be, you want to think about incremental relief. So in other words, maybe don't think about, I'm going to go start a complaint or file a motion or whatever it is at the PUC, and it's going to take us years and we have to win everything. No, think about incrementally, what kind of gain could we get at a commission? Maybe that's information to base cases. Maybe that's information to study anything related to your study, anything related to the transparency of the studies, interconnection costs, anything that could incrementally allow you to improve the likelihood that your project will be approved and not get stuck or drop out of the queue with you having spent millions of dollars. What our recommendations is this. There are other attorneys in the United States, some of them, actually most of the ones I found are on the East Coast, that can help you seek relief at a state PUC or even perhaps an RTO or ISO or FERC. Whoever they are, they should be willing to work with either your in-house technical subject matter experts or outside counsel. Me as an attorney, I always work with technical experts. They make my job a lot easier. I am not an engineer, but I can speak with engineers, I can speak with electrical engineers, and as I work with them, we can usually find, and actually we always find, a very good solution for the developers, for my clients, and reaching out to either the incumbent utility, the RSO, ITO, region, whatever it is, we can, mixing legal acumen with technical expertise, find solutions for you.
So Ruben, we've got a quick question here in the chat. Can an IC file a complaint to PUC even if the GIP is governed by FERC?
Maybe. You always have certain rights at the state PUC level. So we'd have to look at the definitions of what kind of a party you would be, and also what rights you have under any interconnection agreement. So the answer is, I hate to say it, but maybe, most likely you will have some rights at the state PUC. And then, like I said, you don't necessarily have to file a complaint. Working with counsel like myself or technical experts, we can help you develop a strategy for something maybe short of a complaint. So again, yes. And again, I'm going to point this out to you, incremental relief. Our aim is not to essentially, or your aim shouldn't be to essentially go to court and have this long protracted battle, and then after 6 months or 2 years, find something that really works for you. No, in some cases, it really is about simply getting the incumbent utility or the cooperative to the table. And sometimes that requires an entity like the PUC or FERC to get them to that table. So think about that. The other thing is, in conclusion, I'm going to skip that last point because I'm going to address it here. First of all, if you're thinking, well, some of these rights and these grounds for relief don't exist in my state PUC, or even perhaps in my international country, in a country if you're from outside the United States, I highly doubt that. These principles are administrative principles that are essentially mirrored in every single state PUC, at FERC, and in many parts of the world. I've worked in Mexico with Mexican regulators, in Alberta and British Columbia with those two regulators, and in every single region, they have similar administrative principles. So don't think that these bases for relief are not available to you. The second point is this. These are generally the steps for interconnection. I'm sure you have people, development engineers, you have development and project managers, you have attorneys that are dedicated to the financing, perhaps to tax equity structures, how you partner with different investors or different companies. And you have these people up front helping you, making sure that your project is not going to be violative of any federal laws, finance laws, contracts, anything like that. But think about this, the likelihood of your project failing, if 17.5% of projects succeed, that means as of 2021, 82% of projects are going to fail or may fail. That may include one of your projects. So if that's a very high likelihood, my encouragement would be to talk to your team and say, in this step 1 through 7, where is our strategy for dealing with the likely inevitable interconnection bottleneck, the logjam? And if not, what are you doing about it? That may involve maybe starting from a PPA and IA and looking at rights that you have under that PPA or IA, maybe delegation rights or different rights that you could use to lengthen the likelihood of your project being able to stay in queue. Regardless, however, big picture, your strategy or your interconnection strategy should involve probably the PUC and some rights that in some cases you will have to enact at the PUC. We can help you develop that strategy to decrease the likelihood that your project will fail. However, it's not us. Do it in-house. It is a major in today's regulatory landscape at any regime, whether a state, federal, or regional regime, the likelihood that your project will fail is very great. So again, I'm going to ask you, what's your strategy for doing that? If you have any questions, feel free to reach out to me, Ruben Arredondo, or my colleague, Kalani Morse, and we'd be happy to answer your questions. So let me go to Q&A. Any questions so far?
So Ruben, I've got a question here that, I understand that there are some state level, particularly here in Hawaii, some initiatives to enact legislation that would apply to the local utilities to try to free up some of these log jams. How would you see the strategy that we're looking at here working in concert with or supplementing that type of legislation?
Yeah, thank you. I'm a firm believer, having worked at the state commission, and for those of you that have interacted with state commissions, a good strategy involves legislative strategy, whether that's you individually or working with your industry. But I definitely think if these are some issues, ultimately going to PUC is going to be a stopgap. Ultimately, you have to have those issues fixed permanently. And the way to do that is either the PUC passes rules or the legislature passes a law or something in the middle, for both of them act together. So I would always encourage you to work with your either a lobbyist or a law firm that can help you express your concerns to the legislature or even your PUC. And that should perhaps be one track of your overall strategy, where you have a legislative strategy, legal or litigation strategy, and you have an in-house management strategy.
Yeah, that makes all the sense in the world, to not just rely on one strategy to get your project across the finish line and meet your connection date.
Correct.
So I think that's what we have so far in terms of questions.
I did have two questions emailed.
Go ahead, get those first, and then we'll get this third one.
Yeah, so this question I have here was essentially this, and developers, you'll see this issue. Well, these issues are great, but if, for example, if I'm going to a point of interconnection and that point of interconnection is at capacity, there's nothing I can put, there's no more electricity I can put in that. For example, the example I've used with somebody is like, I have a cup here. This bottle can only hold so much water. And if this is a point of interconnection, Ruben, there's no way, no lawsuit or anything is going to put more water into it. And that's true, but I think the real question and the real challenge is, how do you know that? In some cases, you will have an incumbent utility only telling you certain information about a point of interconnection, or perhaps only giving you information about 1 or 2 points of interconnection. Are there other points of interconnection that have more capacity? Are there line ratings that could be adjusted? I'll give you an example on this end. FERC essentially, if you look at line ratings right now are rated in this way. You essentially look at the typical way the line is operated, the environmental conditions that the line is operated at, let's say in summer or spring or fall. And then based on how much energy you plan to go through that line or transmission line, you give it a certain rating. And let's say, I'll simplify it to say, this line is rated for me to use it at 80%, or it's being 80% used all the time. Well, that's not really the case if you look at those line ratings. You may have it used at 80% between, let's say in the summer times, between 5 and 9 p.m. That's really when it's at 80%. But there's other times in the nighttime and the afternoon, certain times of the area where that percentage is much lower. And FERC has recently passed a rule that has allowed transmission companies to readjust their ratings. And so you'll see ambient ratings and dynamic ratings coming down the line. And those will open up the ability for more renewable generators to put energy on the wires of these utility companies. So what I'm getting at essentially is information. Don't just assume that what information you're given is the truth. If you have doubts about it, or if you don't know and you're just being given conclusions, that's something that you should work with your attorneys or your technical subject matter experts.
Okay. All right, so thank you for that. We got another question here. RMP schedules 32 and 34 in Utah address renewable energy facilities and QS 5,000 kilowatts and larger. What are your suggestions to ensure that similar schedules are offered in other Pacific Corp territories?
So Rocky Mountain Power is in Utah. Each tariff is going to be governed by FERC and also the state. So as far as Rocky Mountain Power is concerned, those schedules were probably specific to Utah. However, if you have an attorney, if you have a consultant, they should be able to look at tariffs or schedules and see if there's a comparable tariff or schedule to apply in a particular state, maybe a neighboring state. For example, in Utah, the neighboring state would be Nevada. And in fact, Rocky Mountain Power and Nevada Energy are owned both by what's Buffett's Berkshire Hathaway. Yeah. So the one thing I would encourage you to do in that case is do what Kalani suggested, is perhaps going to the PUC, maybe working with the legislature. Even before that, going to the incumbent utility. There are some areas where a utility is maybe willing to give you a certain benefit of certain schedules or do a one-off schedule that the commission may approve. So I would encourage you first, go to the incumbent utility, see what they can do for you. If you can't do anything there, go to the commission and see have a consultant or some other expert look at this local tariffs and schedule and see what's available there that may apply in other states. And then ultimately, if you can't find anything there, another option may be to go to the legislature and PUC and ask them for relief.
Okay, thank you. Another question. One of your slides mentioned something about addressing cost allocation as a thing developers could seek out. Do you mind talking about what you meant by that a little more?
Yes. So it's let me talk about here. Well, I'm not going to find it, I guess, but it's essentially, I'll give you an example. Somebody comes to you, incumbent utility says, here's your cost for interconnection upgrades. And it may be a line item, something 100 million or 40 or 50 million dollars. And they may or may not give you information as to how they reach that number. And that goes to one of the points that I brought up to say, are these upgrades really allocatable to reliability and safety upgrades, or is there gold plating here? What I would do is I would look at past PUC orders to see if the incumbent utility had ever received settlements or orders related to that particular point of interconnection or transmission line. And if so, did the incumbent utility ever make the upgrades that they promised they would make, that they received money for? And if not, are you as a developer now being assessed some of those costs? We'd have to look at your particular circumstance with technical subject matter experts, people with some experience in rate paying, and really essentially attack the basis for those interconnection upgrades. We have resources, technical experts that testify at FERC and PUCs available to us, that's one of their main purposes, is to look at studies, look at interconnection costs, and attack the underlying basis for how that incumbent utility reached those costs. At FERC right now, I'm sorry, in fact, FERC just recently settled a case. It took 9 months. One of the main complaints from the developer was that initially, at the time they reached their interconnection agreement, they were given a $33 million bill that was their interconnection cost upgrade. Later on, after some more studies, the incumbent utility raised it to 99 million. So $66 million, how did that happen? And what happened was the developer, in conjunction with their outside counsel and their expert witnesses, attacked the basis of that. They finally reached a settlement. The amount was disclosed, but my guess is that it was enough of a number for them to dismiss it. So simply put, we have to look at your situation. We have to look at the costs, look at the bases with a technical subject matter expert for how those costs were reached, and then we can give you some pointers on how to attack this or how to approach the utility for either more information or asking them to drop the amount down with a technical reasoning as to why it should drop down. And finally, ultimately, leave it up to you to decide whether you go to the PUC to ask for relief.
Thanks. Yeah, and ultimately, at some point, you got, some developers, got to be prepared and ready for the concept of, the utility not necessarily wanting to play ball, but ultimately only responding to some sort of a litigation posture. And I think that's what you're talking about, bringing to the table here, which heretofore really hasn't been done a whole lot.
Correct. And in every single one of the state dockets, if you look at the news beforehand, the industry news, they were already in talks. They were already, the developers had already approached the incumbent utility to ask for relief, but they hadn't been willing for whatever reason. It was only when they went to the Public Utility Commission or FERC that the incumbent utility or cooperative was willing to come back to the negotiating table.
All right, we got another question here. What exact rights do ICs have on the state PUC level for the GIP governed by FERC?
So I think we answered that one.
Okay. All right.
Again, it's specific to your state. You'd have to reach out to us and see. We'd have to look at the state tariff schedules, state rules, and see what rules you have. Yes, you're governed by FERC, but doesn't mean you don't have state rights as well.
Okay. Yeah, and then Melanie here is asking for a revisit to your water bottle / cup metaphor. Are you saying that the point of connection is critical and the utility may be overselling this point?
No, what I'm saying is it has to do with the landscape of how power is produced. Let's say, imagine you have this circle and this is the grid. And I'll just use a very simple example. Within this circle, there's one point of interconnection that an incumbent utility is saying, this is where we can take capacity. Perhaps it's in a region, maybe it's even in an island, that this is really the only point of interconnection and the only substation that can take extra energy. And so what I'm saying is, some people will say, you're telling me, Ruben, you're telling me to go sue so I can put more energy on this point of interconnection, when in fact, I have to actually pay money so that point of interconnection can accept more energy. And what I'm saying is, in some cases, yes, that's true. This point of interconnection can only handle so much water. If it's at full capacity, that's it. The utility is right. Somebody's going to have to pay to build that out. The challenge, though, the real challenge is what I've been finding is that most of the time there is insufficient evidence to determine whether this is really full or whether the incumbent utility or cooperative is telling you, yeah, it's full and this is the best place to go. No, you might need more information to identify maybe on this circle, hey, there's this other point of interconnection and it's closer to my project. Maybe I could wheel the energy if it's available, but there's different options. We'd have to look at your particular order. It's just simply looking at the information that is available to you and understanding, is it really a case of this point of interconnection or these lines are constrained? Or is it, I don't have any information to really make that assumption on my own? And if you don't, then there may be other ways for you to get at that information. Again, we're winding down. Is there any more questions?
Yeah, I just got one last question here, and this is just to maybe share with folks. It's no surprise to a lot of folks who have investigated or have projects on the ground here in Hawaii. That getting the interconnection process moved forward certainly could use some help and assistance. And just based on your experience and your interactions with folks on the ground here, how successful would you see this strategy working here on the ground?
I think it's very successful. I think right now you have a lot of state utilities commissions that are very open to developers seeking or trying to enforce their rights at the commission. Obviously, we can't make any guarantees. I can't guarantee you anything, but it's surprising to me to see how many projects dropped out of the queue or drop out of the queue without anyone ever trying to enforce their rights at a state utilities commission, especially at a time when so many utilities commissions are acutely aware of the fact that we have renewable energy goals within my state or region, and we have to meet them. And we will not meet them if only 17% of projects keep getting approved and hung up at the interconnection process. I understand there may be some companies that will say, you know what, this is not for me, and it's just a cost of doing business. And that's fine. I understand that. But there may be some other entities that think, you know what, this is a make or break situation for me. If I don't have this project approved and I can't get past this bottleneck, that's my whole company. And so if that's the situation, you may want to look at taking action at the state PUC.
Okay, well, I think that's our time. We're thankful for everyone who attended today and for your questions. We got a number of requests here for folks to connect with us on LinkedIn, and we'll be happy to do so. Our contact information is up on the screen. Feel free to shoot us emails, check us out, give us a call, let us know if you have questions. We're always happy to jump in and help. So thank you to Ruben today for sharing his expertise and experience with us, as well as his vision for how to undo these log jams. So thank you everyone for joining us today.
Thank you. How many did we have? Do you know?
Excuse me, Ruben. Ruben, can you hear me?
I ask people to email us.